My name is Sean Lowe, and I'm an attorney with the law firm Flow Legal. And today we're going to talk about how to litigate on a budget. Two things that do not seem to go together. First, we want to set the stage for what litigation actually is. And one way to think about litigation is it happens in 4 stages. The first stage is what we think of as pre-litigation. All the things that happen or don't happen before a lawsuit is filed. And that can be as little as exchanging a letter or nothing. And the party who is sued finds out about it when they are served with the lawsuit. The second phase involves what we call the actual litigation. And that is the filing of the lawsuit as well as something called discovery. And discovery is sort of like it sounds, where each party in the lawsuit is trying to learn about the claims or defenses that the other party is raising. And at the same time, they're also trying to find more evidence to support their own claims or defenses. Now, the third phase of litigation is what we think of as the trial itself, which is what we all sort of understand as when the lawyers all gather in the courtroom before a judge and perhaps a jury and plead their case with evidence. Now, the best way to think about the trial phase of litigation for purposes of today, it includes not only the trial, but all of the specific trial preparation that occurs in the weeks and months leading up to the trial itself after the discovery phase. So those are our first 3 phases: pre-litigation, litigation, including discovery, and trial. Now, the fourth phase is pretty uncertain because most cases actually never get to trial. So they don't get to this fourth stage either. They could, and what we call that stage is either appeals or collection, which is even after you win at trial, well, you still have to collect on whatever that what we call the judgment is, or what some people think of as the verdict. And that can involve quite a bit of work. Now, the first phase, as we discussed, often doesn't involve a lot of work at all. It just depends. The second and the third phases, though, do involve a significant amount of work. And they often involve something like an equal amount of work. That should tell you something, which is that when you're preparing for trial and in trial, that involves an intense amount of work as opposed to the years leading up to trial, which are spread out. Now, you might be thinking, what does it all cost? Because that's what we're here to discuss today. The answer is pre-litigation might not cost a whole lot because there isn't a whole lot of attorney work involved. On the other hand, filing the lawsuit, the discovery process, we know that involves a significant amount of work. And the best way I like to estimate that for clients is it's almost never going to cost less than something between $2,000 and $5,000 each month. Now you might be thinking, well, that kind of sounds like a lot of money. And it is. So how does it all add up? Well, generally speaking, that's probably actually going to only equal to about 10 hours of attorney time. So if you think about it, 10 hours in a month, it's not really a significant amount of time for all of the various things that can go into litigation, including reviewing documents closely, which can take a long time, as well as presenting issues to the court. And the other thing I advise clients on is that if you want to do something big or important or abnormal, that's going to add to the cost of litigation. So that estimate of a few $1,000s a month, it's going to be more than that in any given month when you've got those bigger events happening. Now you might be thinking, well, why does it have to be that expensive? Well, part of the reason is a concept known as due process. We all have some idea of what due process is, but essentially it's a number of safeguards that have been put into place that create a ton of paperwork. A quick example would be if I want to ask something fairly straightforward, but maybe there's a little bit of a dispute involved, and I have to bring that in front of a judge, that's going to take 10 hours of work. Even if it's as simple as I want to move a deadline in a case. I want something else to happen. 10 hours of work is often what that takes if you can't get the other side to agree. And of course, if you're in litigation, it can often get hard to get the other side to agree to almost anything. Now, you may have heard, well, wait a second, arbitration. I've heard of this process. Isn't that cheaper? Well, actually, it often isn't. The reason is because unlike judges that you go in front of in a normal courtroom, arbitrators, or what you might think of as a private judge, you have to pay for them. Judges in a typical courtroom, they're paid through your tax dollars, not arbitrators. So what that means is that in addition to paying for your own lawyers, that also means you're having to split the cost of the arbitrator in some way. So that, in a sense, is how arbitration can become more expensive. Now, to kind of the big question, which is, well, how do you do it on a budget then? And the answer is, despite those costs that we laid out, the way that we try to achieve budget efficiency is, first, we try to avoid duplication. And duplication is surprisingly rampant among lawyers. If you've ever seen a lawyer invoice, you'll see at least a few attorneys doing work on the case. And in theory, that actually makes sense. But in reality, if you start looking, you start thinking to yourself, wait a minute, it sounds like they're doing the same thing. So that's one way we try to avoid that. The second way is we try to have more affordable hourly rates. And then the third way we try to avoid it, among others, is we append things remotely. This is something that was sort of possible, but sort of not well utilized even just a few years ago. But now with technology and acceptance, we can often do things remotely and save clients all the costs associated with travel. Finally, we also use artificial intelligence in a real, tangible way. And that's one of the ways that we can perform legal research even faster than we already do. So those are some of the ways that we try to bring some of these costs down. If you have a question about how we can potentially represent you in litigation and how we could do so in a budget-friendly way, please feel free to reach out. Probably the best way to reach us is via email. You can reach me at john@flowe.biz. If you send me an email there, I'll check it out and I'll get back to you. And we can talk about what are the different strategies that we can really use to try and achieve your goals through litigation, but do so in a budget-friendly way. And of course, settlement and an early settlement is going to be part of that conversation. Thanks for listening today. Let me know if we can help, and we'll be in touch.